A warm welcome to this quiz in which we will be seeing 10 multiple choice questions on the fundamentals of the Indian Evidence Act. The answer is B, fragmentary legislation. It is not true about the Indian Evidence Act. You see, the Indian Evidence Act is actually a consolidating legislation. What that means is that in 1872, when the Indian Evidence Act was enacted, it consolidated the law of evidence, which was otherwise scattered and different in different parts of the country. However, that does not mean that it is exhaustive. The Indian Evidence Act is not exhaustive on the law of evidence because the law of evidence is contained in other places as well. For example, you have provisions in the CRPC as well as in the CPC which tell you very important provisions regarding the law of evidence. Likewise, I think it's quite commonly known that it is largely a law of procedure. Chapter 2 of the Act deals with the relevancy of fact, and therefore, relevancy basically means the test of materiality, or the fact that evidence must be confined to the matters in issue. This is also called the test of materiality. This is a fairly simple question. If you want to look at the relevant provisions, then you can have a look at Section 5 to know that evidence must be given for relevant facts and facts in issue only. And you can look at Section 58 of the Indian Evidence Act to know that evidence is generally given only for disputed facts. The answer to this is irrelevant. If the statute is silent, which means that it is neither declared to be relevant nor it is declared to be irrelevant, then it is to be treated as irrelevant. This is because of Section 5. Section 5 says that evidence can be given only for facts which are declared to be relevant and of no others. So if you look at Section 5, you'd realize that the answer to this is B. The answer to this is appreciation of evidence. The stage of appreciation is the stage wherein the evidence is actually weighed and then the determination is made as to which evidence is reliable and which one is not. This is fairly simple. Chapter 3 tells you as to what kind of facts need not be proved. And the chapter immediately preceding that, chapter 2, tells you as to which kind of facts may be proved. If you look at section 5, it tells you that facts in issue and relevant facts may be proved. And then the remainder of chapter 2, from section 6 to 55, gives you a list of various kinds of facts that may be proved. Section 58 of the Act says that facts admitted need not be proved, which means if a fact is admitted by both the parties, which means that both the parties agree upon it, it means that there is no need for adducing evidence. And that basically means that if a fact is not disputed, there is no need for evidence to be produced. The answer to this question is fairly obvious by just looking at the title of the chapter. It reads, "The Exclusion of Oral Evidence by Documentary Evidence." You know that a contract between A and B could be either oral, right? So if B says something, that is also a contract. And if something is written down, that is also a contract. So you realize that in some cases you have evidence that would have to be oral, and then sometimes it would be documentary. And to decide as to which evidence would prevail or be relied upon, we look at Chapter 6 of the Indian Evidence Act. The Indian Evidence Act concerns itself largely with the admission or rejection of evidence. You must note that the appreciation of evidence is the prerogative of the judge, which is done by using what is called the wisdom of the court or the wisdom of the judge, or you can even call it judicial wisdom. This is not based on the Indian Evidence Act, right? Also, obviously, not all evidence is recorded. It is only the admissible evidence that is recorded. Therefore, the answer is option A. Section 60 of the Indian Evidence Act says that oral evidence must be direct, right? The opposite of direct is indirect. And we know that hearsay evidence is a kind of indirect evidence because it is not said by the person who actually saw it, who actually heard it, or who actually sensed it. Dear students, thank you for your patience. In case you have any questions, you may ask me in the comment section below.